you're selling a home that's held in a trust, this video could save you months of frustrations, thousands of dollars, and potentially prevent family conflict before it even starts. Because I've seen this happen over and over again. A parent passes away, a family inherits a home, and everyone assumes selling the property will be the easy part. Then reality sets in. Suddenly, there are legal documents nobody understands, multiple family members with different opinions, questions about pricing, repairs, taxes, disclosures, and timing. Before anyone realizes it, what should have been a straightforward sale become emotional, stressful, and complicated. The truth is, selling a home in a trust is not necessarily difficult, but it's different, very different. And most trustees do not discover that until they are already in the middle of the process. Today, I want to walk you through everything trustees need to know, the biggest mistakes families make, the delays nobody talks about, and the paperwork can stop a sale, and the strategies that can make the entire process smoother. Because if you are the trustee, you are not just selling a house, you are managing a responsibility that affects an entire family. My name is Remarf with the Rafe Group here with the XP Realty in the Santa Clarita Valley. And over the years, I have helped many families navigate trust sales, inherited properties, and some very emotional transitions. One thing I've learned in all that time is the house usually is not the hard part. The people are, the emotions are, the decisions are, and this is exactly what we're going to talk about today. So let's start with the biggest misconception about trust sales. Many people believe a trust sale is basically the same as any other home sale. It's not. From the buyer's perspective, it may look almost identical, but behind the scenes, everything is different. When you're selling your own home, you are making decisions for yourself. When you're selling a home in a trust, you're making a decision on behalf of the beneficiaries. You are acting as a trustee. And that means every decision matters, every document matters, and every conversation matters. Your responsibility is not simply getting the property sold. Your responsibility is protecting the interest of everyone involved. One of the reasons trustees feel overwhelmed is because most people never expected to become a trustee in the first place. Usually, the responsibility arrives during one of the most difficult seasons of life. A parent passes away, a loved one becomes incapacitated, or a family transition occurs. Suddenly, you are responsible for a house, financial accounts, legal paperwork, family communication, and major financial decisions all at the same time. You're trying to make smart choices while navigating grief, family dynamics, and entirely new set of responsibilities. That is why many trustees feel overwhelmed before the property is even listed for sale. And one of the first mistakes families make is assuming they have unlimited time. The house sits, months pass, utilities continue, insurance continue, property taxes continue. Maintenance issues start appearing. Before long, the property begins costing the family money every single month. Now, that does not mean every trust property should be sold immediately, but it does mean families should start gathering information early. Information creates options, and options create control. So let's build that information foundation right now. And let's talk about what a trust actually is and why it changes everything about the home sale works. A trust is a legal arrangement where a person called the grantor or trustor places their property into a structural that is managed by a trustee for the benefit of named beneficiaries. The trust document is the rule book. It outlines the trustee's powers, the beneficiary's right, and the terms under which the assets can be managed and eventually distributed. When a home is held on a trust, the trust itself is the legal owners of the property, not the individual. That distinction is what makes everything that follows different from a standard home sale. In California, there are two primary types of trust that come up most often in real estate. The first is revocable living trust. This is the most common type. The grantor creates it during their lifetime. maintain full control over the assets, and can change or revoke it at any time. They often serve as their own trustees while they are alive and mentally capable. When the grantor passes away, a revocable trust automatically becomes irrevocable, meaning it can no longer be changed, and a successor trustee stepped in to manage and eventually distribute the assets according to the trust instruction. The second is the irrevocable trust. Once it's established, an irrevocable trust generally cannot be changed without the consent of all beneficiaries. These are often used for tax planning or asset protection purposes. The trustee authority may be more restricted in unrevocable trust than the requirement for selling properties may be more specific. So understanding which type of trust you are dealing with is the first step, because it tells you what rules apply and what authority you actually have. Now let's talk about the most important legal concept every trustee needs to understand before anything else. Before you call a real estate agent, before you schedule showing, and before you order a dumpster for a garage clean out, you need to confirm that the trust document gives you the legal authority to sell the property. This sounds basic, but it's more common than most people expect. Nearly all modern trust arguments contain explicit powers giving the trustee the authority to sell real estate. California Probate Code also gives trustees certain default powers, including the authority to sell assets when necessary to carry out the trust purpose. However, older trust documents or trusts that are created without comprehensive estate planning guidance may have gaps. The trustee authority may be limited, conditioned on beneficiary approval, or simply unclear. An unclear authority creates disputes, sometimes very expensive, very time-consuming disputes. So the safest approach is to have a trust attorney review the document before you take action related to the sale, not after something goes wrong. Before you begin, a qualified attorney can read the trust, confirm your authority, identify any limitations or requirements, and give you clear guidance on how to proceed. This is investment of time and money at the beginning of the process, prevents far more expensive problems later. So once you have confirmed with your authority, this is a second critical step that many trustees skip, and it's one of the most common sources of problems I see in trust sales. You must formally accept your role as a trustee. If you are successor trustee, meaning you're stepping into a role because the original trustee has passed away or became incapacitated, you may need to sign an affidavit of successor trustee or similar documents that formally establish your authority. This document, along with a copy of the trust and the death certificate, if applicable, is what title companies, escrow officers, and buyer's lender will need to verify that you have the legal right to sign on behalf of the trust. If these documents are not in order, the transaction can be delayed or derailed of the title and escrow stage, or often when everyone thought they were days from closing. In California, selling a home in a trust also requires what's known as certification of trust. This is a document typically prepared by an attorney that confirms the trust exists, is valid, and grants the trustee the authority to sell. It's a condensed version of the trust that provides the essential information without revealing the private details of the entire trust document. Title companies and buyers lenders routinely requires this. Get it early in the process, not after you are already in escrow. And now let's talk about notification requirement, because this is once a surprise many trustees that can create significant delay if it's not handled correctly. California law requires trustees to notify all beneficiaries of the trust and administration. Under California Probate Code Section 1606 1.7, when a trust becomes irrevocable, typically upon the death of the grantor, the trustee must send a specific notice to all beneficiaries and heirs. This notice includes information about the trust, the trustee's identity, and the beneficiary's right to request a copy of the trust documents. And here's why this matters for the timing of your sale. After notification is sent, beneficiaries have the period of time during which they can contest the trust. In California, that period is 120 days from the date of the notification or 60 days when the beneficiary receives a copy of the trust, whichever is later. Until that contest period expires, moving forward with the sale carries risk. If a beneficiary contests the trust after the sale, the transaction could be challenged. This is one of the most hidden timing delays that families do not anticipate. And it's why starting the legal process early is so important. Waiting until you are ready to list to send beneficiary notification and then discovering you have 120-day waiting period is not a position you want to be in. So now let's talk about the documents needed for the actual sale, because this is an area where having the right agent and the right teams make an enormous difference. A trust sale in California requires specific documentation. A standard sale does not. You will need the trust agreement itself or the certification of trust. You will need any applicable death certificates. You will need the affidavit of successor trustees, and you will need to confirm there are no liens or encumbrance on the property that need to be cleared before closing. And critically, the listing agreement and all purchase documents must be signed with your trustee designation, not just your name. Your name follows by the words as trustee of the name of the trust and the date of the trust. Signing without that designation creates a title defect that can delay or kill the transaction at closing. This is a detail that inexperienced agents sometimes miss, and it's entirely preventable. Now I want to talk about something that most people in this situation are not thinking about enough, and that is the stepped-up tax basis, because this is one of the most financial significant aspects of a trust sale, and is one that trustee and beneficiaries often do not fully understand until after the sale, when it's too late to take full advantage of it. Here's how it works when a property is included in someone else's estate at the time of their death. The cost basis of that property is stepped up of its market value on the date of the death. So what does that mean in plain language? Let me give you an example. Your parents purchased a home in Santa Clarita in 1985 for $180,000. Over decades, it grew in value. At the time of their passing in 2025, for example, that home was worth $900,000. The stepped-up basis means that for tax purposes, the cost basis of the property is now $900,000. The fair market value of the date of death, not the $180,000 your parents originally paid. So if the trust sells that home 6 months later for $920,000, that tax capital gain is only $20,000 difference, not $740,000. That is an enormous tax advantage that most heirs would lose entirely if the property had not been properly structured in a trust or if the sale had happened under different circumstances. But here's where trustees sometimes make a costly mistake. They wait too long to sell. The longer the property sits after the date of death, the more it may appreciate beyond the stepped-up basis, and the larger the potential capital gain becomes. In a California market where values can move significantly in a short period, every month of unnecessary delay is potentially adding to the tax exposure to the beneficiaries. This is a conversation that needs to happen with a CPA who understands estate and trust taxation, not just a general tax preparer. Only in the process, the timing of your sale relative to the stepped-up basis of the most important financial decisions of the entire transaction. Now let's talk about disclosures, because trust sales in California have specific and often misunderstood disclosures landscape trustees need to navigate carefully. In California, sellers are typically required to complete transfer disclosure statements, commonly called TDS, which is a detailed form where the seller discloses everything they know about the condition of the property. However, California Civil Code Section 1102.2 includes an exemption for certain types of sellers, including trustees administering a trust. provided that they have no personal knowledge of the property's condition. If you are a successor trustee who did not live in the home or have direct personal knowledge of its condition, you may be exempt from the TDS requirement. However, and this is critical, being exempt from TDS does not mean you have now no disclosure obligations. You are still legally required to disclose any non-material facts about the property that could affect its value or the buyer's decision to purchase. If you know the roof leaks, you must disclose it. If you know there was prior water damage, you must disclose it. And if you know there is neighbor's dispute or noise issue, a prior insurance claim, you must disclose it. The TDS exemption removes a specific form requirements, not your fundamental legal obligation, to be honest. Additionally, California Civil Code Section 1103 requires the natural hazard disclosure statements for all property transfers in California, with no exemption for fiduciary sellers. This is the form that tells buyers whether the property is in a flood zone, fire hazard, severely zoned, or earthquake fault zone, or other designated natural hazard area. In 2026, given the dramatic changes of California insurance market and the expansion of fire hazard zone designations, this disclosure is more important and more consequential than it has ever been. Buyers will review it carefully, their agent will scrutinize it, and misrepresentation on the natural hazard disclosure, even unintentional, creates liability. My recommendation and the recommendation of most experienced California trust attorneys is to complete the TDS regardless of the exemption. The small additional effort of completing the form is far outweighed by the legal protection and provides against post-sale claims of non-disclosure. A buyer who later discovers a condition they believe was not diagnosed has grounds for a lawsuit. A seller who completes the TDS has a documented record for what was disclosed and when. In a trust sale where the stakes are high and the emotions are already elevated, that protection matters. Now let me talk about something that is the heart of almost every difficult trust sale I have been part of, and that is family dynamics. Because the legal process, as complicated as it can be, is often the easier part. The harder part is managing a group of people who are all grieving, all have opinions, and all may have very different ideas about what should happen with their family home. Let's be honest about what often happens. There are 4 siblings. One lives locally and has been caring for the property. One lives out of state and just wants the money distributed as quickly as possible. And one has no emotional attachment of the home and is resistant to selling at all. And one has all their own financial situation created urgency around the timing of distribution. All 4 are beneficiaries, all have opinions, and the trustee, who may be one of those siblings or someone outside the family, is legally responsible for making decisions that serve all of their interests equally. This is where trust sales become genuinely hard, and it's where the role of the trustee is most misunderstood. The trustee is not the mediator. The trustee is not required to get everyone to agree. The trustee's fiduciary duty to act in the best interest of the beneficiaries as a group. And that sometimes means making decisions that not everyone is happy with. Understanding the distinction between the trustee decision-making authority and the beneficiary's right to input is essential. Beneficiaries have the right to be informed, they have the right to receive accountings, and they have the right to contest trustees' decision they believe violate the fiduciary duty. What they do not have is the veto power over every decision the trustee makes, unless the trust documents specifically requires their consent. A trustee who understands this clearly, communicates consistently with all beneficiaries, documents every decision carefully, and makes choices they can defend as being in the best interest of the trust. Is a trustee who is protected, a trustee who allows beneficiaries pressure to push them into decisions they know they are in the best interest of the trust, or who avoids making decisions to keep the peace, is a trustee who is creating liability for themselves. So here's the advice I give every trustee I work with about the family communication. Over communicate, even if there is nothing new to report. Send a brief update, even the news is not what the beneficiary was hoping for. Deliver it directly and clearly. Silence creates suspicion, and suspicion creates conflict. And conflict in a trust administration can derail the sale, damage family relationships permanently, and in some cases end up in court, which is worst possible outcome for everyone. A trustee who communicates proactively, documents everything in writing, and maintains transparency throughout the process gives the beneficiaries less to be suspicious about and less to dispute. Now let's talk about pricing, because as a trustee, your obligation is not simply to sell the home, it's to sell it as fair market value or better. That is your fiduciary duty, and that means pricing must be approached as a professional financial decision, not an emotional one. So here's where I see trustee make significantly and costly mistake. They price the home based on what the family needs or want from the sale, not what the market will bear. A trustee who price above market value because the beneficiaries want more than the data support is violating the fiduciary duty just as surely as a trustee who prices below market value for personal reasons. The trustee's job is to get the strongest defensible price the market will support, and that requires the same rigorous data-driven pricing analysis we use for any home sale. Get a professional appraisal, have your real estate agent prepare a detailed market analysis, understand what comparable homes in your area have actually sold for, not what they are listed at, not what the beneficiaries think the home is worth, and not what Zillow says, what the market has actually paid for similar properties, and price your listing based on that evidence.